All right. So let's start with today current affairs. Let's stay sharp and exam relevant, right? So सबसे पहले तो हमारे पास है शबरीमला का verdict. So the Supreme Court is hearing review petitions against its own 2018 Sabrimala judgment, which allowed women of all ages to enter the Kerala temple. The temple's tradition barred women aged 10 to 50 years, and the original verdict by a five-judge bench struck this down as unconstitutional. अब हम देखेंगे कि मैटर क्यों करता है, क्योंकि यहाँ पे रिलीजियस फ्रीडम वर्सेस इक्वालिटी की डिबेट है। जैसे कि आर्टिकल 25 गारंटीज द राइट टू प्रैक्टिस एंड प्रोपेगेट रिलीजन, while Article 14 guarantees equality before law, and Article 15 prohibits discrimination on grounds of sex. The 2018 judgment held that excluding women violated gender equality. The review petitions argue that this interferes with the essential religious character of the temple under Article 26, right? So अगेन एसेंशियल रिलीजियस प्रैक्टिस टेस्ट अगर हम इसको देखें तो कोर्ट कहता है कि एसेंशियल रिलीजियस प्रैक्टिसेस डॉक्ट्रिन टू डिटरमिन विच रिलीजियस कस्टम्स डिजर्व constitutional protection, right? The 2018 bench held that excluding menstruating women is not an essential practice to Hinduism. Review petitioners argue that the court cannot decide what's essential to faith. That's what for the religious community itself, right? That's for the religious community itself, right? जो 9 judge bench reference है उसको हम देखें तो the current bench has referred 7 key questions to a larger 9 judge bench. These include whether a religious denomination's right to right under Article 26 can be restricted by the equality provisions of Articles 14 and 15, and what test should courts apply to determine essential religious practices. उसके बाद हम देखेंगे रिव्यू पिटिशन। ये होता है एक लीगल रेमेडी सीकिंग रिकंसिडरेशन ऑफ सुप्रीम कोर्ट जजमेंट बाय द सेम कोर्ट, एंड आर्टिकल 25 constitutional provision guaranteeing freedom of conscience and right to practice religion to all persons. Article 26 right of religious denominations to manage their own affairs in matters of religion. उसके बाद essential religious practices to test determining which religious practices are protected under Article 25 and Article 26. Constitutional morality, concept requiring adherence to constitutional values of equality, liberty, and dignity over tradition. और Indian Young Lawyers Association, right? जो petitioners हैं in 2018 case who challenge the age-based entry restriction for women. तो keywords भी हो गए। अब हम आगे बढ़ते हैं next topic की ओर, which is महाराष्ट्र 5% Muslim quota. तो so what happened in this? महाराष्ट्र गवर्नमेंट ने अनाउंस किया है कि 5% रिजर्वेशन दी जाएगी मुस्लिम्स को in education and government jobs, categorizing them under the socially and educationally backward classes. Now, this takes the state total reservation to 68%, exceeding the 50% cap set by the Supreme Court. अब देखते हैं कि why it matters. The Indira Sahni limits challenged, right? So the Supreme Court in Indira Sahni versus Union of India 1992 held that reservations cannot exceed 50% of total seats except in extraordinary circumstances. Maharashtra already has 52% reservation for OBCs, SCs, and STs, and now adding 5% more breaches this ceiling. The state will likely argue this qualifies as an extraordinary circumstance based on backwardness data. Religious based conservation debate अगर हम देखें तो इसमें यह है कि the constitution under Article 15 and 16 allows the reservation only on grounds of social and educational backwardness, not on religion. So the 2004 की EV Chennai judgment held that a group identified solely by religion cannot be granted reservations. So Maharashtra's moves classifies Muslims as SEBC, arguing backwardness based on socio-economic indicators, not religion per se. अगर हम social and educational backwardness को देखें तो the state must demonstrate thorough empirical data that Muslims as a group face social and educational backwardness. Such a committee की report ये कहती है कि it documented Muslims socio-economic conditions nationally. Maharashtra will likely rely on similar state level data on literacy rates, income levels, and employment patterns to justify this classification, right? अगर हम इंदिरा साहनी केस देखें तो उसमें भी लैंडमार्क 1992 सुप्रीम कोर्ट जजमेंट था अपहोल्डिंग रिजर्वेशंस बट कैपिंग देम एट 50%. जो 50% कैप है, in case you don't know, it is Supreme Court imposing ceiling, ensuring balance between reservation and merit-based opportunities, right? Article 15(4), which is about constitutional provision enabling state to make special provisions for advancement of backward classes. Article 16(4), provision allowing reservation for backward classes in government appointments. फिर क्रीमी लेयर जो है वो है कि concept excluding better off sections within backward classes from reservation benefits, और SCBC Act 2017 Central legislation establishing National Commission for socially and educationally backward classes. नेक्स्ट टॉपिक और बढ़ते हैं विच इज़ इंटरनेशनल फ्लीट रिव्यू. तो ये बहुत इंपॉर्टेंट है सिक्योरिटी एंड डिफेंस के पॉइंट ऑफ व्यू से. इंडिया इज होस्टिंग द इंटरनेशनल फ्लीट रिव्यू 2026 with INS Vikrant, India's first indigenously built aircraft carrier, as the centerpiece. Over 50 nations, including all Quad partners, ASEAN countries, and major European naval powers, पार्टिसिपेट करेंगे इसमें इन द मैरिटाइम एक्सरसाइजेज ऑफ मुंबई. सो ये मैटर क्यों करता है, ये हमें देखने की जरूरत है, क्योंकि इंडिजिनस कैरियर ऑपरेशनल डेब्यू, राइट. INS Vikrant, commissioned in 2022, is India's first domestically designed and built aircraft carrier. This demonstrates India's shipbuilding capability and reduces the dependence on foreign naval hardware. The carrier operates MiG-29K fighters, jets, and advanced sensors and weapons systems integrated by Indian defense PSUs like BEL and BDL. अगर हम maritime diplomacy and quad ties की बात करें तो fleet review serves as maritime diplomacy, right? Showcasing India's naval capabilities to partners and deterring adversaries. Participation by US, Japan, Australia strengthens quad naval interop or joint exercises during the review enhance coordinated operations in Indo-Pacific, particularly for maritime domain awareness and humanitarian assistance. Indian Ocean naval dominance की अगर हम बात करें तो India seeks to be the net security provider in the Indian Ocean region, where China is expanding its naval footprint through the string of pearl strategy. अब INS Vikrant जो है gives India blue water navy capability, the ability to operate far from home shores. Now, this is critical for securing sea lanes through which the 80% of India's trade by volume passes. इसमें कीवर्ड ध्यान देने की जरूरत है, जो कि INS Vikrant, India's first indigenously built aircraft carrier, commissioned in 2022, it displaces about 45,000 tons, right? For international fleet review, again a multinational naval gathering showcasing maritime power and fostering naval diplomacy. Indigenous aircraft carrier जो कि warship designed and built domestically, reducing strategic dependence on foreign suppliers. Then Blue Water Navy is naval capability to sustain operations far from home ports across open oceans. Or Indo-Pacific strategy, जो कि India's strategic focus on the maritime region from East Africa to Pacific Islands. Then Make in India Defense, which is initiative promoting domestic manufacturing of defense equipment and reducing imports, right? Towards the next most important topic in social welfare, social issues and welfare. Again, एंजल चकमा का जो केस है, सुप्रीम कोर्ट ने एंजल चकमा का केस सुनते हुए कहा है कि द केस इन्वॉल्विंग असॉल्ट ऑन ट्राइबल स्टूडेंट्स इन बेंगलुरु हैज called for specific legislations to address hate crimes and racial attacks. The court noted that existing IPC provisions are inadequate to deal with racially motivated violence. It matters because hate crime legislation है नहीं, it is needed. India lacks a specific hate crime law that recognizes racial or ethnic identity as an aggravating factor in crimes. Now, IPC section 153A deals with promoting enmity between groups but doesn't enhance punishment for crimes motivated by hate. Countries like US and UK have hate crime laws that impose stricter penalties when crimes are committed based on race, religion, or ethnicity. Tribal protection gaps in IPC, इसमें जो scheduled tribes they face unique vulnerabilities, right? Discrimination based on facial features, language, dress, custom. SC noted that tribal students from Northeast India routinely face racist slurs and violence in mainland cities, while the Scheduled Caste Scheduled Tribe Prevention of Atrocities Act 1989 exists. It doesn't cover racial attacks by non-SC/ST perpetrators on tribal victims. ये बहुत ध्यान देने की जरूरत है. तो कॉन्स्टिट्यूशनल सेफगार्ड्स जो हैं वो इनएडिक्वेट है. आर्टिकल 15 प्रोहिबिट्स डिस्क्रिमिनेशन बट डजंट प्रोवाइड अ मैकेनिज्म फॉर एनहांस्ड punishment for hate motivated crimes. Article 29 जो है protects cultural rights of minorities but offers no deterrent against racial violence. कोर्ट ने सजेस्ट किया है कि पार्लियामेंट नीड्स टू इनैक्ट अ कॉम्प्रिहेंसिव लॉ ऑन द लाइंस ऑफ प्रिवेंशन ऑफ एट्रोसिटीज एक्ट स्पेसिफिकली फॉर रेशियली मोटिवेटेड ऑफेंसेस. तो इसमें जो एंजल चकमा का केस है, अगेन केस बिफोर सुप्रीम कोर्ट इन्वॉल्विंग असॉल्ट ऑन ट्राइबल स्टूडेंट्स हाईलाइटिंग रेशियल वायलेंस. जो शेड्यूल ट्राइब्स हैं, इंडिजिनस कम्युनिटीज रिकॉग्नाइज अंडर आर्टिकल 342 with constitutional protections and affirmative actions. IPC section 153A is provision punishing acts promoting enmity between groups on grounds of religion, race, or hatred, or religion, race, or community. Sorry, hate crime law legislation recognizing identity-based motivation as an aggravating factor in criminal offences. Again, Article 15(4) constitutional provision enabling special provisions for advancement of SC and ST. Protection of Civil Rights Act 1955 legislation protecting civil rights and preventing disabilities based on untouchability. Right. Next topic, again very important, JPC on simultaneous polls. So what happened? A joint parliamentary committee has been constituted to examine two bills on simultaneous elections. one proposing synchronization of Lok Sabha and state assembly elections, and another bringing local body election into the same cycle. Now, this follows the high level committee report of 2023 recommending one nation, one election. Why it matters? One nation, one election feasibility. So, let me break this down for you. One nation, one election feasibility, जो है, it proposes holding Lok Sabha, all state assemblies, and local body elections together every 5 years. Now, proponents argue that this reduces election expenditure, policy continuity improves, governance improves. Governance is not disrupted by constant election cycles. But इसमें the election commission estimates कि 4 से 5 elections, you know, uh, happen somewhere in India every year currently, costing thousands of crores and imposing model code of conduct frequently. मॉडल कोड ऑफ कंडक्ट लगभग 200 दिन चलता है. So constitutional amendments required. Uh, Implementing one nation, one election requires amending Article 83, 172, 174, and 356. The biggest challenge is what happens if a government falls midterm. The proposal suggests that fresh elections only for the remainder of the 5 year cycle, which requires complex constitutional restructuring and likely needs ratification by at least half the states. अगर हम फेडरलिज्म वर्सेस गवर्नेंस का की डिबेट देखें तो उसमें critics argue that one nation one election centralizes power and undermines federalism. State elections become secondary to national elections. Regional issues get sidelined, and voters may not distinguish between state and central governance. Supporters counter that voters are mature enough to separate national and state issues, pointing to simultaneous elections until 1967, when the cycle broke due to midterm dissolutions. Keywords क्या है इसमें? One nation one election, proposal to synchronize Lok Sabha assembly and local polls, joint parliamentary committee, cross party parliamentary committee examining legislation and providing recommendations to parliament. Right? Article 83, constitutional provision fixing Lok Sabha term at 5 years unless dissolved earlier. Article 172, which is provision fixing state legislative assembly term at 5 years unless dissolved earlier. 122nd Constitutional Amendment, which is proposed amendment to enable simultaneous elections introduced in 2025. Then High Level Committee 2023, which is panel headed by former President Kovind examining one nation, one election feasibility. Again, the next very important topic is Competition Commission of India versus WhatsApp, Meta, right? Big tech. So what happened? The Competition Commission of India has imposed a penalty on WhatsApp and Meta for abusing their dominant position in messaging and social media market. The case involves WhatsApp's 2021 privacy policy update that forced users to share data with Meta platforms or stop using WhatsApp. Now this matters because digital market abuse or dominance. So WhatsApp has over 500 million users in India, making it dominant in the instant messaging market. The Competition Act Section 4 prohibits abuse of dominant position through unfair or discriminatory conditions. CCI held that WhatsApp leveraged its dominance to force acceptance of data sharing, which users could not refuse without losing access to the platform. अगर हम डेटा शेयरिंग प्रिवेसी वायलेशंस को देखें तो हम इसमें देखते हैं कि the 2021 policy required WhatsApp users to share their transaction data, device information, usage patterns like with Meta's other platforms like Facebook and Instagram for targeted advertising. But this was challenged as violating information privacy and user autonomy. The timing is crucial. This predated the DPDP Act 2023, and CCI is using competition law to address privacy concerns. Competition Act 2002 enforcement जो है वो है कि CCI has been increasingly scrutinizing big tech companies like Google, Amazon, and Apple for anti-competitive practices. This case establishes that dominant digital platforms can't use take it or leave it terms. It also signals that CCI will examine data practices through competition lens, even when separate privacy law exists. Right? Competition Commission has statutory body under Competition Act 2002, regulating market competition and preventing monopolies, abuse of dominance, unfair practice by dominant market player, leveraging position to impose unreasonable conditions. WhatsApp privacy policy 2021 updated terms requiring mandatory data sharing with Meta platforms. Meta platforms क्या है? Parent company of Facebook, Instagram, WhatsApp after 2021 corporate restructuring. Section 4 of the Competition Act says a provision prohibiting abuse of dominant position in relevant market and digital markets, online platform and technology driven markets subject to competition regulation. So I think that's today's session. Stay consistent, stay sharp. See you tomorrow. Thank you.